Good afternoon, Judge Mbatha.
Good afternoon, Chief Justice.
Are you well
Yes, thank you.
and comfortable?
I beg
Or
your-
are you comfortable and relaxed or as nervous as I have been, or some of us have been appearing before this body?
Hey, I'm nervous, but
All right. Let's start at the beginning.
yes.
When and where did you acquire your degrees?
My degree, yes, I acquired my BProc degree at the University of Zululand.
When was that?
That was in 1983.
83. So we met there without knowing each other, or were you not you were not a student in 83, but 81, 82 you were there?
Yes.
Okay.
Yes.
Okay. I can't disclose the reason why I don't remember you very well. It might be quite interesting. So. Anyway,
Yes.
And then what happened after 83?
Then I served articles of clerkship, whereupon then I worked as a professional assistant for a few months, and then I opened my own practice in
Yes.
Newcastle.
Yes.
Yes.
And for how long in totality did you act as a High Court judge?
I acted as a High Court judge from 2005 to 2006, which were two sessions in 2005 and again 2 sessions in 2006. Then I returned back in November 2010 up to the time when I was appointed as a judge on the 1st of June 2011.
And when were you were the 1st of June 2011, you were appointed permanently.
Permanently, yes.
Have everybody there, including your male colleagues, been welcoming as they ought to be, or not?
We're at the KZN High
Yes,
Court.
yes.
Yes, they were very much welcome.
And they gave the support that ought ordinarily to be extended to an acting judge and a newly appointed judge.
Yes, I got the support.
When did you begin to act at the Supreme Court of Appeal, and until when?
I started acting at the Supreme Court of Appeal from the 1st of December 2016 up to the end of November 2017.
Was it the last time you acted?
Yes.
How did you find the environment? Let's first deal with the environment. Was it a welcoming environment? Everybody available and willing to help? What is it you can say about the environment at the SCA upon arrival and some time after you had been there?
Yes. Yes, upon my arrival at the SCA, I found the colleagues that were very much keen to help and very much keen to assist. Well, when you start there, you cannot tell the first few weeks how things are going to shape. Then you start to get to know people as you start writing the judgments. Then you can see the extent of the help and the extent of the collegiality that you receive from them. Yes.
Broadly speaking, would you say everybody was very helpful and welcoming, or not quite?
Yes. Not everyone, but the majority were very helpful, I would say, which made it much easier for me to adapt. Yes.
From time to time, we receive comments in relation to candidates to the effect that, they are not ready, they could use additional acting things. If any such comment were to be directed your way, what would be your response?
My response would be, I do not think that I need any more acting stints. I think having the whole year, spending the whole year at the SCA, showed to me that I could cope with the work at the SCA, as it was an unbroken stint. And as I progressed, I saw the improvement from each term compared to when I started at the SCA.
Are there any areas in relation to the operations of the SCA that you would say require urgent attention, or even if not urgent, serious attention?
At the SCA, I would say it is important that everyone should feel accepted if we are coming there as an acting judge, that they should accept that we have been invited by the president of the SCA to act, that they should not decide who should be invited at the SCA.
Elaborate on that. What does that mean in simple terms? What is the real nature of the challenge so that we can understand exactly what the concern is there?
Yes. In simple terms, I would say that I felt there was some kind of a gatekeeping process from a very few people, because you would hear comments that this one is not suitable to be here, this one should not have been here to come and act. And you also see it when you've got to write a judgment, because this starts even before you write a judgment. I don't mind any robust criticism of my judgment, but when the criticism starts before you even write a judgment and you get threats that the judgment is going to be taken away from you, I found that very much intimidating.
Taken away in what sense? That you will no longer be allowed to write it, it will be given to someone else to write?
Yes. If I can elaborate, we had a matter, I think it was when we started the term. 3 or 2 days later, the presider was already asking if my draft is ready.
How?
And my response was that it's a huge matter. It was about 17 volumes, and we've just finished, and I'm still preparing myself to revise for the other sittings. I wasn't ready. He was not happy with that. The following week, the same thing happened. Then he threatened that he'll take the judgment away from me. Before the end of that week, again, then he said, if I don't give him the draft, I've got to co-write with someone. But however, I felt strong. I said, no, I'm going to write the judgment, because all my hearings are within the first 2 weeks. I'll be left with the full 4 weeks. When I'm ready, then I will write the judgment, then I will give you the draft. Yes.
Now, was that your experience alone, or as people often do, during your wound-licking process or exercise, did it come across as a shared experience with some of the acting colleagues there, past or present at the time?
Yes. We used to be more or less on the same panel with Judge Mlimela from the Free State. That's where in this panel, whenever we were with this particular person, we'd get this intimidating attitude, which I found it was really, which I found unsettling.
Yes.
Yes.
Yes. And what would you say has prepared you, or how would you say you have prepared yourself for the Supreme Court of Appeal to have applied as you have now done? In your own words, as briefly as you can.
Yes. I have prepared myself in terms of my work. In my judgments, they show that I've applied the constitutional principles, and besides the judgments, I get on very well with other judges at the SCA, and whenever I've got problems, I approach them, and I've found that having Justice Maya as the president at as the SCA, as a female and as a person who always checks up on us on how we're doing, that has helped us quite a lot to settle in that environment.
Yes. President Maya?
Thank you, Chief Justice. Good afternoon, Judge Mbatha.
Good afternoon.
I don't have any questions for you, really. Chief Justice has asked everything I would have elicited from you. Just one thing, though. Did you find that in your year at the SCA, you were exposed to the widest possible range of legal questions?
Yes. Thank you, Justice. Yes, I was exposed to the widest legal work. For instance, I recall in a panel where the president was presiding. It was a case where 4 female judges were there and only 1 male. It was a patent law judgment. I really enjoyed that one, though I do not get that much kind of work from my division. And when Justice Zondo came for his interview here, he had said he's still yet to see a judgment on patent law written by a female, without knowing that on the 31st of March, Justice Dambuza had penned a judgment where there were 4 female sitting judges with one male, and a judgment which we all enjoyed and contributed to. So at the SCA, I found quite a lot of also administrative law work, a lot of the application of the constitutional principles, quite more a diverse kind of work than from the provincial division.
Was there any one occasion where you felt out of your depth in the hearing of those appeals? Were you able to cope? That's the simple answer I want to ask you.
Not at all, because I do not recall where there was a matter where I felt out of depth. If I had missed a point, I would openly say I could see where I had made a mistake when we're discussing in conference that's where I missed the point, but I felt I could cope with the work.
And were you able to participate fully during court proceedings and during the judges' private deliberations in chambers after the hearings?
Yes, I was able even to pose questions, though as an acting judge, you are scared, you don't know whether to pose questions or not, but I was able to do so. Also at conferences, because at times the presiding judge would start with me being the junior judge to first give the views on the matter, then I would go ahead and give the views. Also at times when I would scribe in the matter, I would be the first person to be asked to give of how I see the matter and give my views on the matter.
You were even able to produce a dissent in one matter, a class action matter that raised new questions of law for our judicial system. In Mahiane, I think we sat together in that case.
Yes, I wrote a dissenting judgment in Mahiane versus Mahiane. It was about a silicosis matter where the DJP from Housing Justice Mujapilo had granted a certification application in that matter, and this related to an application in terms of PAIA. So we dissented. That dissent that I wrote, I really enjoyed it because I also got the support from the president. We dissented against the president of the SCA and other 2 judges. We did not feel any hostility. We felt that to be very much empowering, as Judge Mlimela also wrote her own dissenting judgment in that matter.
Thank you, President Maya. Commissioner Fourie? Your mic is on.
Good afternoon, Judge Mbatha.
Good afternoon, Mr.
Judge Mbatha, there's one matter that I am concerned about and which I feel duty-bound to raise with you. And that is a matter where you convicted and sentenced 9 accused in October of 2016. And they were sort of a syndicate with a common purpose to target automatic teller machines of banks in KZN, etc. Do you recall the matter?
State versus Makazi and others?
That's right.
Yes.
Now, I understand you are aware, all 9 the accused then appealed. And in respect of all 9, on the 2nd of March of this year, and I understand you are aware of that judgment, the full bench set aside the convictions and sentences in respect of all 9. You are aware of the full bench judgment, aren't you? And what is concerning to me is in the conclusion of that judgment, the following is stated by the full bench. And I need to have your view and insight into what is stated there, because if not addressed, it's very concerning. I must immediately say I have not read your judgment in the court of quo, but it says, in conclusion, there was no reliable evidence before the court au quo to sustain a conviction on any of the counts, and the appellants ought to have been acquitted. If I may just pause there, the convictions included murder, attempted murder, etc. And then the following paragraph. Counsel for the state has confirmed that in the court au quo he did not seek a conviction against the appellants in respect of the counts set out in paragraph 4 supra. Notwithstanding this, the learned judge convicted the appellants on those counts. No reasons were given why she disagreed with the submissions and concessions made by the state. In fact, the judgment did not record the concessions made by the state at all. They were ignored. In our view, a court declining to act in accordance with such concessions made by the state is duty-bound to explain where the state erred. In this case, this was not done. As a consequence, the 1st, 3rd, 4th, and 5th appellants were sentenced to 3 life terms of imprisonment in circumstances where the state had conceded that there was insufficient evidence against them. It is indeed so that the evidence presented in the court au quo raises strong suspicions against the appellants. However, it is trite that suspicions do not amount to proof beyond reasonable doubt. And then the order that the appeal is upheld and all the convictions and sentences are set aside. Could you enlighten us as to exactly what happened here, and can you deal with what I've read to you was stated by the full bench on the 2nd of March of this year?
Yes. Thank you, Mr. Fourie. I thought we were referring first to the first ATM judgment, which I had included, that is State versus Makazi and others, where there were also 8 or 9 accused, the one that was confirmed. This one was also an ATM bombing. It's a trial that lasted for almost the whole year, which I did at the KZN High Court. It was based mainly on circumstantial evidence. We had cell phone evidence, we had the finding of the cartridges, spent cartridges, ballistic evidence, informer evidence, all those kind of evidence. There were lots of gray areas, I admit, in that judgment. it was not a clear-cut case where you would simply say, I acquit or I do not acquit. What I recall in that matter is that I acquitted only accused number 10. Then, when I had given judgment and conviction, there were about 38 counts from various sins, various places all over the country. They made an application for leave to appeal. When the state tried to oppose it, I personally, it's in the judgment for leave to appeal that I said, I want this judgment to go on appeal because there are lots of gray areas. I would like to send this judgment to my peers so that they can look at it, because I'm also not certain on certain issues. On the issue that the state advocate had conceded to certain counts not having been proved, I justified it on the basis of the finding of the cartridges, because those cartridges were linked to the same firearms that were found in the certain or in their possession. I was alert to what the state advocate had suggested, but I applied my mind that if I include certain sins and link them to these cartridges, why should I exclude those? But it's a judgment that I was also expecting, that rather than saying I'm refusing leave to appeal, as the state advocate was saying, that let me grant leave to appeal so that it can be reviewed by a bigger group or by the 3 judges in a full court.
Judge Mbatha, the main criticism by the full bench is that no reasons were given why you disagreed with the submissions and concessions made by the state. In fact, the judgment did not record the concessions made by the state at all, and they were ignored, and that in the full bench's view, declining to act in accordance with such concessions made by the state, the judge is duty-bound to explain where the state erred, and this was not done. Is this fair criticism?
Well, it could be a fair criticism, but the judgment says also why I convicted on the basis where the state was saying I shouldn't convict.
Did you, just as a follow-up in my last
Maybe
question,
it was an oversight not to say that, well, as the state has suggested this is why. But my judgment encompassed that I convict in all those counts because of the finding of these spent cartridges, because of their matching with the firearms used, because of the cell phone evidence. That's how I had couched my judgment.
just a follow-up and final.
Another follow-up. I think
No,
you're
no,
overstretching it
just a
now.
quick issue of
Yeah.
clarity, Chief
No, just to say you are overstretching it, let it be the last now.
Yeah. I just want to get a clear answer from you. Did you record the state concessions, and did you in your judgment deal with why you do not agree with what the state conceded?
No, I did not record the state concession.
Thank you, Chief Justice.
Thank you, Commissioner Fourie. Commissioner Ngozi Thomas.
I wanted to make a follow-up question, to direct a follow-up question, but on reflection, I'd rather not.
Thank you. Now, if anybody wanted to understand what your views are vis-a-vis the concession made by the state, even if you don't deal with them directly, would it be possible for a person to understand why, notwithstanding the concession, you concluded in the manner that you did?
Yes, Justice. Chief Justice, I did so.
Is there a principle that you can remind us of, a legal principle, that says of necessity the concession by the state carry the kind of value that requires of a judge to deal expressly with those the rejection of the concessions?
Yes, I'm not aware, but what I'm aware of, Chief Justice, is that any concession that has been made by council does not necessarily mean that the court is bound by that concession.
Yes.
The court should be independent, exercise its discretion if it needs to exercise its discretion or its mind, and see how it should apply the law to the facts.
Yes. Thank you very much, Judge Mbatha. You're excused.
Thank you very much, Chief Justice.
Thank you.